everyone, and welcome back to Lawmera. If you're new here, I'm Fabiola, a business attorney dedicated to helping you navigate the legal side of your entrepreneurial journey. In our previous videos, we covered the basics of different business structures, and today we're going to be diving into an equally important topic and one of my favorites and one of the most common things that I do every day, which is business contracts. Understanding how you draft and review contracts is crucial for any business owner. What exactly is a business contract? A business contract is a legally binding agreement between two parties that outlines the terms and conditions of their relationship. These can include employment agreements, service agreements, partnership agreements, non-disclosure agreements, just to name a few, but there are so many out there. Let's go ahead and start by reviewing a few key elements of every business contract. And so every valid contract must include the following. I know this is going to sound a little basic. However, you'd be surprised at the number of contracts that I read and I deal with and I've seen that tend to miss some of these important key elements. Every valid contract must include the following: offer and acceptance, which means one party makes an offer, the other party accepts. There must be consideration, which means something of value is exchanged between the parties. There must be mutual consent. All parties must agree to the terms. There must be competency and capacity. So the parties involved in the contract must have the legal ability to enter into a contract. So 18 and over, for example. And there is the legality of purpose. So the contract's purpose must be legal. It sounds kind of weird, but you just can't go ahead and have a contract for like a illegal drug deal. Illegal being that there's just no way to enforce that. Now let's look at some common clauses you'll find in business contracts. So this includes confidentiality, very common, and this ensures sensitive information is not disclosed. So if you're very concerned about someone knowing something, this is a clause that you're going to have to look at very closely. There's also termination, the conditions under which a contract can be ended. This is incredibly important as well because you need to know how either you can get out of a contract or the other party can get out of a contract. Another really important clause is dispute resolution. How is the dispute going to be handled? Do you guys have to go fully through the court system to be able to resolve an issue? Or, do you guys go through mediation or arbitration, prior to? So those are really important, and you have to be thinking about what that would look like. We don't want to, but it's very important. There's also going to be liability and indemnity clauses, who is going to be responsible for what. And lastly, but definitely not leastly important, payment terms. Details on how and when payments will be made. Sometimes it's very simple. Here's a contract. I'm going to do this service and you're going to pay me X amount of dollars. Sometimes it could be a little bit more complicated in regards to maybe you're shipping a product. There could be additional terms where the person is able to inspect the product before it gets there. That's going to open up that liability opportunity for some party to have to deal with if, the good isn't what was promised or it was damaged in shipping. All of those things can get pretty complex. So payment terms are definitely something that needs to be very clear. A really general understanding of what the landscape looks like for a business contract. First and foremost, I am a big proponent of clarity and simplicity. There is no need to make things a little complicated. I will tell you this, that if you tend or want to write a contract for whatever reason in some complicated language for the other side to not understand or for the other side to have some sort of disadvantage, this will not work out well for you, because if you draft, there's certain legalese here. If you draft a contract, it can be construed against the drafter. That's some pretty basic legal jargon there. Best and rule of thumb to create a contract that is clear and simple and that everybody understands their obligations, everybody understands their responsibilities, so that everyone is going to be on the same page. I really don't believe in creating business contracts that are unnecessarily complicated. Granted, there are some times when an agreement is going to be complicated, and I've worked on agreements that are 80 pages long. That is not simple, but it is clear. So that's really important. Another tip is to be very specific and detailed as you're drafting this contract, right? Include all the necessary details to avoid ambiguity. You know what I mean? These details, again, comes back to everyone being able to understand and know exactly what their responsibilities are. Just include all the details. Do not assume that the other side knows exactly what you are talking about. It's better to be safe than sorry. The other point is to ensure a mutual benefit. So making sure all parties benefit from the agreement. Again, this goes back to just keeping things simple, being straightforward with each other. Very, very easy to accomplish. The other thing would be including dispute resolution mechanisms. As an attorney, one of the things that I look at is, what does this look like if things go bad? Unfortunately, that is a lawyer trick when any lawyer is looking at contracts that they're going to be looking at. Finally, when you're looking at contracts, is to review and revise very carefully and regularly. So if you're a person that is constantly having to delve out contracts for vendors or, whoever, volunteers, whatever it is, make sure to keep them updated. Make sure you're constantly reviewing them and revising them, because there are consistent laws that change over time on certain things. If you're dealing with an independent contractor, that's one thing. If you're dealing with a vendor, that's something else. And there are specific clauses that can apply. Those clauses can be specific to certain counties, to certain cities, to certain states, so some might be permissible in one space, some are not permissible in another space. There are also, unfortunately, the opportunities to be penalized for presenting folks with language and contracts that are not permissible by law. So you have to be very careful to keep reviewing and keep your contracts up to date. The other thing I would say is to read every clause. As attorneys, there are certain clauses that we just become accustomed to and we can read right through them really fast. That can be something that comes to be a part of your business. However, I can guarantee you that every attorney is going to read every clause, even if it's just to say that they reread it a million times and they totally know. It's crucial to read every clause. The other part of that is to understand that legal jargon. Make sure that each of the terms that you use in this contract is something that you understand actually is what it is. Sounds kind of weird, but there are a lot of legal words that are thrown about and used interchangeably. For some attorneys, this is fine. For folks that are in different industries that are, cross collaborating, this can have different meanings. So really understand what the legal jargon is in your contract. And finally, one of the other tips is, if you're unsure, just reach out to an attorney, reach out to me. You'd be surprised at how having a consult initially to review a contract that you're really on the fence about, how helpful it can be if you just invest a little bit of time in connecting with a business attorney. There are so many out there, including myself, that have clients that specifically just do that. They reach out to me when they need just a quick gut check on this contract. They can read it, they understand it, but they just want to make sure that there isn't anything missing or there's something that was not included that should have been included. We're going to switch gears here and we're going to talk about some of the common mistakes to avoid when dealing with contracts. Again, so this is going to look like glossing over the fine print and, again, not understanding these vague terms. It is so important for you to know exactly what you're signing. You don't have to memorize it, but you do have to know what that is. The other tip that I would have is to not consider future scenarios. I think that's probably one of the best tips that I have given my clients to avoid getting themselves into a sticky situation, is to really consider, how will this contract hold up over time and what does that mean? I think we all learned the lessons from COVID. Anything can happen. There's a lot of uncertainty in our future. And so it's important to look at a contract and look at those terms of what that would look like if things just did not go well, if your part of your business burnt down, or part of the other dude's business, burnt down, or what about this girl boss and, her business went sideways. She posted a weird video, whatever. Those are all things that you need to consider as you move forward into your contractual relationships, is what this relationship and contract is going to look like over time. I hope this video has given you a little bit of a better understanding of how to draft and review contracts. Remember, a well-drafted contract can protect your business and provide you some peace of mind. So if you have any questions or topics you'd like me to cover, drop them in the comments below. Don't forget to subscribe to our channel for more business law insights and hit the icon so you never miss an update. Now, while what I am sharing with you are some legal insights, it is not legal advice, and you should consult with an attorney prior to taking any action regarding your business. Thank you for watching, and I look forward to helping you on your business journey. See you at the next video.